My name is Becky Leese. I am the staff liaison between the Council of State Governments Midwestern Office and the Midwestern Legislative Conference Agriculture and Rural Affairs Committee. Joining us today and moderating our webinar are two of our chairs, Senator Teresa Ibaugh and North Dakota State Senator Paul Thomas. Together with the chairs of this committee, I'm pleased to offer a webinar focused on farm succession. As a reminder, this webinar is being recorded, and the slides and presentation will be available on our website following the event, and we'll also send an email to attendees who signed up. So I'm going to turn things over to Senator Ibaugh to introduce the topic.
Very good. Well, thank you, Becky, and thank you for organizing this webinar. I think it'll be really helpful for a lot of us joining today. For the past several years, the topic of farmland ownership has been receiving significant attention and nationwide. For those of us familiar with our rural countryside, we recognize that most farmland is owned by private individual farmers. And as a farmer rancher myself, I can kind of attest to that. You've likely heard or experienced firsthand that the average age of farmers is increasing. What's less discussed about is that the average age of farmland owners is also rising. This trend raises an important question for the strength of our rural economy. Are farmland owners prepared to transfer their land and their businesses to the next generation of farmers to ensure market stability? To help us better understand the complexities of farm succession planning, we'll hear from two experts today, Robert Moore and Jim Molyneux. Suzanne Henricks will also be joining Jim to lend her perspective as well. Plus, Becky will share some comparative findings from the Farmland Issue Brief that she authored on behalf of this committee. So I'll now turn things over to my fellow co-chair, Senator Paul Thomas from North Dakota.
Well, thank you, Senator Ibaugh, and thank everyone for attending today, and for those that didn't attend and watch this presentation later, thank you for taking the time to be part of the MLC and our ag community. With us today for our presenters is Robert Moore. He's an attorney and research specialist with the Ag and Resource Law program at The Ohio State University. Robert grew up on a dairy farm in central Ohio. He attended The Ohio State University, where he earned a BS in dairy science and a master's in ag econ. He later received his JD from Capital University in Columbus, Ohio, graduating cum laude. Prior to joining OSU, Robert owned and operated a law firm for 18 years, focusing his practice on succession planning, taxation, and business entity formation for farmers and landowners. After we hear from Robert, we'll turn things over to Becky and then to Jim Molyneux. Jim Molyneux is the Farmland Access and Succession Team Coordinator for the Minnesota Department of Agriculture. This is a position that was created in 2023 that leverages his experience. For 43 years, he served as a farm business management instructor at St. Cloud Technical and Community College. He is also a mediator for Minnesota's Farm Lender Mediation Program. Like many of us, Jim was raised on a farm. In his current role, he guides farmers and ag landowners through the succession process, coordinating with professionals as needed to ensure success. Jim likes to say he is experienced, but not an expert. I think we'll find he is both. So as we get going, let's get started. And Robert, we'll begin with you. The program is yours.
Okay, thank you. And let me get my slides going here. All right. Thank you for that introduction. And yeah, I was in private practice for many years and worked with many farm families throughout Ohio. So hopefully I can share with you some of my experiences, give you some ideas, and maybe some of the issues that we address on a daily basis in farm succession planning. So first, I'm going to talk a little bit about probate. And I also want to say, as we were developing the program, we decided to hit several topics, maybe at a high level instead of a deep dive. So today's discussion is just kind of get some issues out in the open. It's not meant to be a deep dive with a lot of detail. So just keep that in mind. So avoiding probate, you probably all know what probate is, but let's just do a brief review of that. When somebody passes away, if their assets are controlled by their will, or if they don't have a will at all, that's called intestacy, those assets must go through probate. Probate is part of the county court system. And so what the probate court does is it oversees the estate administration process, basically make sure all the assets are accounted for and they go to who they are supposed to go to. Probate's a really important service that our courts provide to us. But with that said, there are many opportunities to avoid probate. And in my opinion, we should try to avoid probate. So that's going to be the primary focus of this discussion on probate. So how do we avoid probate? Well, it's actually pretty easy in most states. But the first thing is, why avoid probate? Why don't we let it go through the probate court? Isn't that a good thing to have the court oversight? Well, yes, but it can cost. So in Ohio, for example, and I think Ohio is fairly typical, the probate fees, this is what attorneys would charge to administer the estate, is usually between 1% to 5%. Some states are a little bit higher than that. So for your everyday person that owns a house and a car and a bank account, maybe that's no big deal. But for farm estates, we're often talking millions of dollars. And so millions of dollars multiplied by 1% to 5%, that gets to be some real money. And so what we'll talk about is how can we avoid those probate fees and cause the administration fees to be much lower. Executors can also take a fee in the same range. Now, executors are usually family members. They usually don't take the fee, but they can. Another problem with probate is time. It takes a while. If you've ever dealt with probate, if you've ever been an executor, there's just a lot of paperwork, and that's just the nature of the system. So it takes significant amount of times to collect all the assets, submit all the paperwork, get the paperwork back. And there's multiple rounds of filing this paperwork. It just takes a lot of time. Probate's not going to happen in a matter of weeks. It's going to be several months at best, usually, and can be well over a year for more complicated estates. So it takes a while. Public record, a lot of people don't realize that if you just have a will as your primary estate planning document, after you pass away, anybody can look at what assets you owned, the value of those assets. They can read your will and who did those assets go to. Now, some people are like, I'm going to be dead, who cares? But for a lot of people, keeping your estate private is really important. But probate is not a private system. It is a public record. Loss of control. The executor only has limited authority to act. Essentially, the probate court is the ultimate authority, and the executor can only act as far as what is control given to it by the probate court. And beneficiaries can slow the process. If we've got a beneficiary who's upset or whatever reason, and just wants to file motions and delay turning things in, if a beneficiary wants to be a problem, they can be a problem in probate. And just the administrative burden, like I said before, anybody who's been an executor will tell you it's just a lot of paperwork. So let's try to cut down on all of these problems by avoiding probate. So what tools do we have to avoid probate? Trust, transfer on death affidavit, payable on death designations. I'm going to talk about all of these in a little bit of detail. So let's talk about trust. Everybody's heard the term trust, but what is a trust? What's the difference between a trust and a will? A will is basically a set of instructions. It says, when I die, send my assets to these people. And the probate court makes sure that happens. A trust is a set of instructions as well, because a trust will say, when I die, give my stuff to these people. What's different about a trust is it's its own entity. It's its own legal entity. It's kind of like a corporation or an LLC. It can hold assets, own assets, buy and sell. It's its own entity. Because of its own entity, it is outside of probate. And so that's why many people use trust, is that it's its own separate entity outside of probate. We kind of have a little bit more control over a trust than we do the probate process. Now, I often get asked revocable trust versus an irrevocable trust. Now, I could talk on this topic for a couple hours, but to talk about it in a couple minutes here, revocable trust, that's typically the kind of trust most people have. That just means we can set it up, and at any time we can change it. We can completely eliminate it, put assets in, put assets out. Your revocable trust is essentially you. An irrevocable trust, on the other hand, is a trust we set up, we put assets in, and once we set it up, we can't undo it. And the benefit of the irrevocable trust is once we put those assets in the trust, they're safe from lawsuits, nursing home after 5 years, any kind of liability we have, those trusts are protected. But in order to get that asset protection, you give up ownership and control. You set up an irrevocable trust. You no longer own or control those assets. For many farmers, that's problematic. So whenever someone asks me, should I have an irrevocable trust? I always want to have a very thorough discussion to make sure the owner of those assets knows that they are giving up control and ownership. But for our discussion today, both a revocable trust and an irrevocable trust will avoid probate. So let's talk about real estate. Just an example here. Let's say we've got a married couple owns 200 acres of farmland valued at $2 million. Throughout the Midwest, $10,000 an acre, very common. Joe dies, his 50% goes through probate. So just to get Joe's half of the real estate to his wife, Betty, married couples are really surprised when this happens. It has to go through probate if we haven't done any planning ahead. And if we apply, $1 million, 1%, that's at least $10,000 in probate just to get it from one spouse to the other. And, that's that cost that comes in, and it'll take a while. If Betty needs to get financing, a mortgage, sell, it can just hold all of that up. So what can we do instead? We could set up a trust. So Joe and Betty, while they're alive, set up a trust, transfer the land into the trust. Then when Joe dies, it doesn't have to go through probate. Betty owns 100% of the land, and we've avoided all that probate. Essentially, the instant Joe dies, Betty's the new 100% owner. Very easy. Problem is, trust costs money. So I put $5,000. Sometimes it's lower, sometimes it's more, but it's probably going to be several $1,000s to set up that trust. Another thing they can do is most states have rights of survivorship. So Joe and Betty on the deed for that land, say Joe and Betty rights of survivorship. And that way, when Joe dies, Betty becomes the automatic owner. without probate. That's a very simple way to avoid probate for married couples. And then most states allow transfer on death affidavits. So let's say Joe and Betty weren't related. Maybe they were siblings, and Joe wanted his half to go to children or something. You can just do a transfer on death affidavit, and it's similar to a deed, but it just says, I own this half. When I die, I want my half to go to this person. Sign it, notarize it, record it, and it avoids probate. So avoiding probate on real estate is pretty easy in most states. I will say I don't think Iowa allows the transfer on death affidavit, but I think all the other states do. So as long as we plan ahead, we can avoid probate on most real estate. Unmarried, same thing. Here we could do a trust. Probably wouldn't want to do a survivorship because you don't want to co-own the land, but we could do a transfer on death affidavit. So even for unmarried people, still pretty easy to avoid probate as long as we know about it and we plan ahead. So I was just going to compare some fees of probate. If we took what I would call maybe a typical Ohio farm, we've got $2 million of land, $1 million of machinery, livestock, crops, another 500,000 of money, investments, whatever it may be. But if we, in Ohio, it would be 1% probate on the real estate, 2% on the rest of that based on the values. That's a $50,000 bill. That's significant. Whereas if we plan ahead, maybe we do a TOD affidavit for the real estate, and the attorney charges $500. Maybe we do an affidavit to transfer machinery, livestock, and crop. Maybe that's another $500. And then I just added a couple $1,000s for administration, odds and ends. But we can transfer that same, what's that, $3.5 million. We can transfer that same $3.5 million for a fraction of what it may cost in probate. So that's why I really emphasize, let's try to avoid probate if possible. The different probate laws, so where it varies from state to state, like I said, on real estate, it's pretty consistent, except I think Iowa, I don't think allows for the transfer on death affidavit. Vehicles can be all over the place. In Ohio, you can make any vehicle transfer on death. So if it's an unmarried farmer and they want their grain truck to go to their nephew, they can go to the title office, do a transfer on death, avoid probate. But not all states have that. Financial accounts, life insurance, that's where you just go to the bank, call up your life insurance company and said, I need to add beneficiaries to my account. They'll send you the paperwork, you do it, easy. All you got to do is just make the effort to call your financial institution or stop in at the bank. I'm pretty sure every state allows that. Untitled assets in Ohio, we don't have a good mechanism to avoid probate on untitled assets such as machinery, livestock, and grain without setting up a trust. Although I know there's some states where you can sign an affidavit saying, give all my machinery and grain to whoever, and that avoids probate. So I wish we had that in Ohio. And then again, assets held by a trust will also avoid probate. So how can state legislatures help with probate? We're a long ways there. I think every state is pretty good with allowing easy avoidance of probate. But I would say, does your state allow transfer on death affidavits for real estate? Does your state allow transfer on death designations for vehicles? And does your state allow for transfer of non-titled assets with some kind of affidavit? If you can answer yes to all those, I think you're set. If it's no to any of those, that might be a place where you might look to help out our farmers. Okay, so that's a little bit on probate. Estate taxes, you probably all know the estate tax, federal estate tax is $15 million starting next year. A lot of people don't know that about 2 to 3/10% only 2 to 3/10% of farm estates even pay federal estate taxes. So estate taxes are not a big issue for most farms, but for those that have it, we're talking a 40% tax. So for those that are in that 2 to 3/10%, it's a big deal. State taxes, you can see the map there of which states have state or inheritance tax. That's all I'm going to say about estate taxes because I know better to get into any recommendations on tax policy. So I just wanted to make sure everybody was aware of what states had estate or inheritance tax and which didn't. Okay, last I'm going to finish up with a really quick discussion on long-term care. And by long-term care, I'm basically talking nursing home cost. In my opinion, when I started practicing 20 plus years ago, estate taxes were the biggest risk to farm succession. I think it's probably long-term care now. And I think we need to really focus on this and try to encourage producers to do some planning. Although, as I'll show you, there's no easy solutions. These numbers are from the Genworth Cost of Care survey. So if you ever want to know what nursing home cost and in-home care cost, just Google Genworth Cost of Care survey. That's kind of the gold standard of what nursing home cost. But you can see fairly consistent throughout the Midwest of what it costs. But a nursing home, 100,000 plus every year is what that's going to cost. So as you can imagine, that could be really problematic for many farm families to withstand that. Some statistics from the Administration for Community Living, it's a federal government agency. If we took everybody that's 65 years old today, right at 2/3 of them are going to need some type of long-term care. So I just kind of figure 2/3 of everybody, of us, are going to need long-term care. Now, the next question is, how much long-term care do we need? So women will need more, so about 3.7 years on average. Men will need about 2.2. Now, when we talk about long-term care, that includes at-home care and nursing home care, and I'll split that out for you next. Probably the most important statistic here is what I call the outlier. And what that says is 20% of us will need long-term care for longer than 5 years. That's when the bills can really add up. So according to the same Administration for Community Living, if we take a gender neutral 3-year average, of those 3 years of long-term care that 2/3 of us will need, 2 years of it is at home. So that's good. At least a majority of it is at home. And of those 2 years, another good bit of news, 1 year is unpaid. So that would be a spouse, family member taking care of us. 1 year is paid. I use the US average, so about $75,000. And then again, of the 3 years, 1 year would be in a facility. So this is going to be your nursing home. So if we use the national averages on that, on average, for those of us who need long-term care, we're looking at $186,000. And it won't surprise you that these costs go up every day. They're not going down. They're going up, and they're going up pretty fast. Now, so that's a significant bill, although I would say many farms can withstand it without having to liquidate assets. Not all, but I think most could probably stand it. If we bump this up and say, well, what if we're in that 5-year outlier? What if we're in the nursing home for 4 years? Now we're over $500,000. Now we've got a lot of farms at risk. And so when I say long-term care is the biggest risk to farm succession, it's this slide I'm talking about, because there's going to be about 20% of our farms that are going to be facing significant long-term care costs, and they may just not have the resources to withstand that. So what do we do about all this? Well, as I previewed, there are no easy solutions. I wish there was, and I wish I would have come up with it because I would be rich because everybody would want it, but there just simply aren't any easy solutions. So I've just listed 5 here. There's more than this, but maybe these are the most common. What do we do? Long-term care insurance, that's the best strategy. Pay insurance, protects your assets, and we don't have to do any gifting and irrevocable trust. Problem is, it can be expensive, although there's a lot of different types of products we can tie it to life insurance. So I'd encourage you to talk to your advisor about long-term care insurance. But for many people, may not be able to afford it. Also, if you've had many health issues, you're probably not insurable. So long-term care insurance, look into it, but many people are not going to be able to afford it or won't be insurable. Do nothing. Sometimes this is the best approach. Usually when we think of a do nothing strategy, it's bad. But if you have enough income, let's say nursing home's $100,000 and your retirement income is going to be $150,000, well, then we probably don't need to do anything. You've got the income to pay for long-term care. Your assets are safe. So for many people, do nothing is the best strategy. You can gift assets. You can gift all your land to your children. There's a 5-year waiting period. But after that 5 years, those assets are safe from your nursing home cost. The problem is, if we gift them to our children and then that child gets into financial difficulties, gets a divorce, gets a lawsuit. So the gifting protects them from our long-term care, doesn't necessarily protect them from other people's risk. Irrevocable trust, I described an irrevocable trust a little bit there, but same concept. You put it in an irrevocable trust, you have to wait the 5 years. But here, if a child gets into financial difficulties, the trust will protect it rather than it being in their own name. Wait and see. This is what I use many times where we say, well, let's wait and see. Before we gift all the land away, why don't we wait and see if somebody's actually going into the nursing home? If that looks to be the case, then we'll go ahead and gift. Then we'll go ahead and do an irrevocable trust, whichever way may be, and then wait the 5 years. Now that causes about $500,000 of assets to be at risk. So this is there's definitely some downsides to this strategy, but it is a good strategy for producers who have the resources to kind of wait and see. And I did want to mention probate avoidance tools don't protect assets. Transfer on deaths, revocable trust, affidavits, survivorship, none of that protects assets from long-term care costs. That is a completely different matter. So with that, my time is up. If you have any questions, I'll stick around for that. Becky, you're muted. There you go.
Yeah, thank you, Robert. We will do questions at the end. So for now, I'm going to just take this to the screen and talk about some of the latest research that I shared with many of you. When I set out to write an issue brief about farmland ownership, I wanted to explore what was motivating farmers or motivating farmers to hold on to their land through retirement. And from a tax standpoint, I wanted to know why it was easier for them to pass land on to the next generation at death rather than at an earlier point in time. And so to explore the tax implications for farmland transfers, CSG Midwest analyzed a hypothetical $7 million farmland transfer under 3 different scenarios for each Midwestern state. And that resulted in tax liabilities ranging from a low of $31,500 to a high of a high of 2.02 million folks. And so, or dollars per transfer. So the underlying assumptions, the first one, if we go to the next slide there, was in that big blue chart, it says that the land was transferred during an owner's lifetime. So while the husband and wife were still alive, we're assuming that they had a $7 million farmland piece of property, and they jointly owned it, and they have leased the land to their child for 5 years, and they're not actively engaged in the farm operation. So this farmland transfer is happening in 2025. And the assumption for all three of these scenarios is that the land was purchased in 1995 for $1 million and no improvements to the land were made. So while they were alive, the sale generates, they sell the land to their farm or to their child, and they themselves realize $6 million in gains. And so while Robert didn't go into the estate taxes and capital gains tax rates, I'm going to go into that space and compare some of the states in our region. So as you can see, the federal tax rate for selling that land and realizing a gain of $6 million equates to a tax bill of $1.428 million. And capital gains, when that occurs, there's also the state capital gains rate. So in Illinois, for example, the rate is 4.925%, which on that $6 million sale price or $7 million sale price and $6 million gain, you'd end up with an additional nearly $300,000. As we go on, you can see that in Indiana, there is like a county based capital gains tax rate. But in South Dakota, for instance, there is no capital gains. And in Iowa, the federal or the farmland exemption applies. And so in Iowa, there wouldn't be a capital gains tax realized because they are exempt if the farmland is sold to a relative, which was the hypothetical I set up. In Nebraska, their rate is going down from a 5.2% capital gains tax rate in 2025 to 3.99% in 2026. Whereas in North Dakota, they have a general 40% reduction in capital gains before the tax is triggered. And then in Wisconsin, they have a 60% exemption for farmland that's sold to a relative. And so in this situation, only $2.4 million would be taxed at the capital gains tax rate in Wisconsin of 7.625%. So you can see in the right-hand column or the center right column, the total capital gains rates vary to quite a bit depending on which state you're living in. And that's for land transferred during the owner's lifetime. But if the landowner and the farmer waits until the time the land is transferred upon the owner's death, then it looks pretty different because, as Robert indicated, the federal estate tax doesn't kick in until you hit an amount of farmland that's over $30 million or $15 million for a single person and $30 million for a couple. And that is a very small amount. So in our hypothetical, there would be no federal estate tax due. But in Illinois, there is an estate tax. And so the same is true for Minnesota. And there's that inheritance tax in Nebraska. And then in the last column, I wanted to show what happens and why this happens is that when land is sold, or when land is transferred upon a person's death, the concept of a stepped-up basis takes over. So instead of realizing the gain on the whole amount of money that they inherited, they get the fair market value of the land at the time the land was transferred at the owner's death. So instead of it being that I didn't pay anything for the land, and so I realize all $7 million of the transfer, I get the same basis as as the person who I'm inheriting the land from at the fair market value of that. So the fair market value at the time of the owner's death is the same price as what I inherited the land from. Then I wouldn't have any capital gains, and there wouldn't be any amount due at that time. So that stepped up basis really helps, that tax rule really helps people, and it enabled a lot of farmland to transfer to the next generation without having to sell part of the family farm because they didn't realize any gains, so there was no taxation amount, and the farm could stay as one unit. But should you choose to sell that land, so in the last example, the land was sold 1 year after inheritance, And then in that hypothetical, I said that the land increased in an amount of $210,000, and that 210,000 would be the gain. So the difference of the value upon the receipt of the land 1 year earlier, and then that gain would be taxed at the same rates as in the left-hand column. So in South Dakota, where there is no capital gain tax, they just pay the same as the federal rate, whereas some of the other states have higher amounts. And if you want to look through that, I'll make sure to put a link to the farmland issue brief, so you can go through that chart in more detail and pour over all the details as you'd like. But I wanted to say thank you for making the time to hear how that transfer happens, and taxes are very different depending on which state you live in and when you decide to sell the farmland. And I think those are the consequences. Why that matters is we know that farmland value is going up, but the net farm income is relatively flat. So I think people have a tough decision to make when they pass on their land and when they give up control over that asset. So I'm going to switch things over to Jim to go and talk about what's happening with the farmers he sees as they're trying to make succession plans, and to talk about what his work entails. So Jim, with that, I'm going to see if you're still on and able to take control of the screen. We'll switch over to your part of the program. And just make sure you're unmuted. In the meantime, let me see if there's any other questions that have come in. Oops. All right. Jim, can you switch to your audio?
I'm ready. Just tell me when you're ready, Becky.
Yep, go ahead.
Okay, thank you. So one of the things, two topics to focus on here. One is, as legislative members, what can you do maybe to help your state that you might be able to learn from our experience? And second is just directly to farmers that might be participating. And obviously, this is a real complex topic, so we won't cover everything. But one of the things I find is that farms don't start the process because they don't know where to start. It is so complex that they will avoid facing the issues till it's too late. So helping people know how to start, when to start, and what is a stop. I was already introduced, so I don't need to share that, but I'll point out that every farm has a story. And I find that storytelling is a real part of this process because people are very proud of their farms and what they've accomplished. And in telling their story, oftentimes you can get to the issues that they're facing, and it brings a comfort level and a communication. And I'll just point out that every farm needs a good dog that can drive a Bobcat skid steer loader. And aging is not for sissies. I think as we age, it's not for the faint of heart, but people are not alone. But there's many moving parts in this process, and it can be stressful. We do stress that planning is so important. There certainly are legal issues, and I appreciated Robert's presentation and Becky's information, but it's probably a bigger topic for a farm to face. And so we really emphasize that planning can help improve the odds. It doesn't guarantee the odds, but without planning, the odds are not as good. I'd like to introduce also my colleague and team member is on this call, Suzanne Hinrichs, and we do approach this as a team in Minnesota. Suzanne is part of Minnesota Extension. I'm an educator, a retired educator, and the Minnesota Department of Ag. We work together. One of our initiatives right now is a QR code to farmers asking about 5 questions about their succession plans. Having information to present to legislative members is really useful. And this is something that we are really trying to focus on this winter, getting people to scan this with their phone and answer some questions. So make a plan, have a team. This chart, when you look at your farm, a key question to a farm is, do you want your farm to continue beyond your lifetime? Because if the answer is no, really what you need is to determine what happens with your assets when you die, and that is an estate plan. And Robert talked about probate, which is a big part of your estate plan. But if you want the farm to continue, you really need to think about, is the farm financially viable for a new generation? What are your goals? What are you hoping to accomplish? And those two things come together in a succession plan. You still need an estate plan, and you also need to consider, what is my retirement plan? Even though most farmers never retire, they may transition to something different than being the full-time CEO of their farm. We use the three-legged stool as an educational model for farms, and I will draw this on a piece of paper. As the farm succession coordinator in Minnesota, we do two things. We offer a retreat. We want the entire farm family to attend for a Friday night and a full day Saturday, and we give them time to, we educate, but we give them time to talk as a family. I'm also made available to visit farms individually to counsel them and help them. And I always explain that I am not an attorney, I'm not an accountant, but in storytelling, they often share things with me that helps them move forward. The three-legged stool is our model, and the three legs are a retirement plan, an estate plan, but business succession is what you can do during your lifetime to help the next generation get established. It may be sharing machinery. It may be gifting. There are many ways to help the next generation get started farming while I'm alive, but once I'm dead, it's really hard to help the next generation get started. So this is our education model. And goals, succession is about goals, economics, management transfer, decision making, the control of assets in your estate. You need a executor. You need someone who has power of attorney for end of life decision making. And retirement. How do you turn over? I've always made all the decisions for my farm. How do you let go of that? How do you train the next person to know what you know? And as a farmer, I'm sure Senator Thomas and Senator Iba, you've a lifetime of experience that you have gained managing your own farms. How do we pass that along to the next generation? So a little more just goal setting, allowing the next generation to start from what we've accomplished and continue on. Communication, it's certainly integral in farm transitions. It's extremely important to talk, differentiate roles, have meetings. Expectations are so important in this process, because unmet expectations, what happens? That can really damage a family. It can really damage a farm. If you're expecting different things as the owner generation from the incoming generation to the non-farm generation. So that's why it's here 3 times. And maybe having business meetings, talking about things, writing it down, sharing information with non-farm family members, and surprises cause problems. One last thing, and I'll wrap up to allow time for questions, but the golden rule, you might think of that, you know that, but the golden rule here is who has the gold gets to make the rules. I'll say that again. The person who owns the farm gets to make the rules. And thinking about your farm and how do we treat our farming successor versus our non-farm family members is really a burden on people. And we use an example of the cattle farm, where if they split their farm up equally, each child would get $1 million. We use this example. That's equal, but is that the most fair thing? Farmer K has been part of this farm for 15 years, helping his parents get established. They've made money because he's there. Well, middle K and special K got through college. Parents helped them through college, and they have good jobs and live in the metropolitan area of Minnesota. And so what they determined is, well, our son, Farmer K, helped us gain some of that net worth. And they evaluated that his share of that farm was about 50%. So he received part of the inheritance just as being the child. And then the $1.5 million that the farm gained during his time would be part of his estate, and middle K and special would get $600,000. Now, there's more explaining to that. That is not equal, but that may be fair. And then communicating this to your children would be very important, because if you wait till you're dead or passed away, people will hate each other when they discover it after you're gone. I'm going to stop there and just say Stephen Covey did this design, and the top right corner is really about things that are not urgent but are important. Like over on the left corner, there are things that are urgent on a farm. The cows are out on the highway. You drop everything to take care of that, or hay needs to be baled, or corn needs to be harvested. But planning, relationship building your estate does not rise to the level of urgency, but it is extremely important. And so that's something we just point out in passing, is make it urgent and important. So this is a more comprehensive approach. I feel very honored to be asked on this call. I feel very honored that the Department of Ag in Minnesota really has called me out of retirement to serve in this role, and I do really appreciate it. And my partner, Suzanne, is on. We do this as a team effort, and then we encourage form your own team. Who should be on your team? Probably your attorney, probably your accountant. Who else? A trusted advisor, a trusted educator, maybe your pastor. But having a team can help you move through the process. So thank you. I'll conclude and appreciate being on the call.
Well, thank you, Jim. I do have I have a question that came in for you, and it's how many farm families do you reach with the help of your succession planning through your work with the Department of Agriculture? What does the state do to promote the word about and get the word out about the availability of state-based succession planning services?
People find us in a variety of ways, but we do have a website at the Minnesota Department of Agriculture, and it's called FarmLink. And FarmLink connects farm owners with people who hope to farm. But this program is also listed there. But Minnesota Extension advertises through their circles. Minnesota State Colleges advertises through their circles. And word of mouth has been one of our great promoters. How many people do we say? I might see 100 people individually across the whole state as individual, and our retreats this winter probably will maybe be 200 to 250 people attending. And it has grown over the years. We started this, the groups were pretty small, but it's growing in popularity, and people give us very high ratings. Like on a 1 to 10, we average about a 9.8 satisfaction, and we're pretty proud of that. Thank you.
Yeah, thank you. I'll stay on you for 1 second. I know that when we met prior to putting together this webinar, I asked you, what does the average farm size look like, and what type of land values are farmers coming to with? If you could answer that. And then there was one other follow-up that I was curious about is,
Well,
what is the biggest impediment to successful farm planning?
I had a farmer on a panel, and they said, you know what, we came to your program one year, Jim, went home and baled hay. We came to your program the second winter, and we went home and manure needed to be hauled. We came the third year, and there was something else came up. And the fourth year when we attended, we finally decided, gee, we ought to do something. So just getting people to start the process. And I find that very common, that just getting people started and forming that team. Surprising how many people don't have an attorney that they have seen for 25 years. They may have a will that we did 25 years ago. They just need to really start the process, communicate with family members who are wanting to come in. Average farm size, that's really hard to answer because it's all over the board. We have many, multi-million dollar farms that estate tax is an issue for them, but we have a lot of small family farms and sometimes widow farmland owners who really need a counselor. It's all over the board. But all of our farms in Minnesota are family farms. We have a very strong corporate farm law. And so even though farms can be large, they're still family farms. And we're open to anyone. But, generally farms that are large and have pretty good asset base may go directly to a professional counselor and bypass the education because they can.
All right, thank you. I think the next question is going to go to you, Robert. It's asking, how does a farm set up as an LLC impact the discussion? And I'm guessing that's more of the how things go from into a trust or out of a trust into an LLC. So if you could comment on that, Robert, that'd be helpful.
Sure. Well, an LLC can help with all of those topics I talked about. So if we put our assets in a business entity, we can usually make that ownership transfer on death. So business entities are a great way to avoid probate. Long-term care, if we put our assets into an LLC, it helps with long-term care. It doesn't solve the problem, but at least it protects those assets. So, LLCs are often used in farm succession planning, often used in conjunction with trust when we have joint ownership. And we want some rules around that ownership so that we don't have individual family members or spouses or creditors forcing the sale of the land. So, LLCs are a very valuable tool.
Okay, excellent. And then sticking with you, Robert, question came in. Probate ensures creditors are paid upon death. How are creditors protected when probate is avoided with a trust or a transfer on death?
Mm-hmm. Creditors would still have rights. It's just that the trust isn't necessarily obligated to contact them. But as long as the creditor is secured, either with a mortgage or a lien, they're still going to get paid. And the creditor can still contact the trust and the trustee to get paid. So I would say doesn't change a lot other than probate provides that automatic notice. A trust does not. So if you're a creditor, you probably want to maybe be a little more, I don't know, up to date on what's happening with the family.
If anybody else has any questions, feel free to put them in the chat or in the question and answer box. I did want to get back to you, Robert, about the percentage that is paid towards probate in Ohio. Is that a high rate? And if so, who receives that money? The county? Does it get distributed to the executor?
Yeah, great point. So the probate fee, what happens in Ohio, and I think this is pretty common in all states, is there's a law that says before the attorney can get paid for their work for administering the estate, the court must approve that payment. Well, judges got kind of tired of looking through attorney bills. So the judges said, okay, as long as your fees are between 1% and 5%, they're automatically approved. And so the attorney will at the closing of the estate, the attorney will say, I had a $5,000 bill. It was 1%, and it's automatically approved and they can get paid. So the probate fees are the attorney fees that are charged to the estate. There may be some additional filing fees, things like that, but those are minor compared to the legal fees charged by the attorney. So I'm glad you asked that question.
Excellent, thanks. Let's see here. I think we got to the questions I had at the beginning of it. Is anybody, I saw that Jim had to hop off of the webinar here, it looks like in a few minutes. Is there any other topics or points you feel like you should have gotten to, Robert, or questions from other participants?
No, I would just say, especially the long-term care, it's complicated and it really takes planning ahead of time. Once somebody goes into a nursing home, there's just really limited options. So, planning ahead for both long-term care and probate avoidance is really key.
Okay. And I have a question about what are some of the things that legislators can do? I think you pointed to some of them at the beginning of the conversation, having those transfer on deaths
Mhm.
as affidavits available. Um,
Yeah, I mean, Medicaid is a part federal, part state program, so potentially state legislatures could, maybe tweak some Medicaid rules to help out. But again, it's pretty limited, and most farmers are not going to qualify for Medicaid anyway.
Certainly. And I would say too, it looks like most of the states, when I was doing some research about farm succession planning, um, most states offer some sort of programming, like the state of Minnesota, where they have an office set up to help put on retreats and whatnot. But what the amount of services that are provided to an individual farm, or the length of and the duration of the educational outreach is limited. Sometimes it's just, webinars. Sometimes it's more in depth, like what we've seen in Minnesota, and what Jim was speaking of, with actual
Mhm.
retreats that are more than a week, take an entire weekend, and you're working with a small group of people. I know in Wisconsin, there's a program that trains farm advocates. They help make sure that attorneys in the space are understand the complexities of working with farms, and have those conversations when you're transitioning uh, from having someone who they identify as a farmer, and it's their livelihood and identity, and it's a little bit different than somebody just passing on their assets, um, when they may have not been invested in their work the way that a farm family typically is.
Yeah, I
Um,
mean, ultimately, you can go to all the education you want, but ultimately, your plan needs to be highly customized to you. And that involves sitting down at the table with the attorney. And maybe if there's one thing uh, state legislatures could do is somehow incentivize more young attorneys to return to their rural communities to do rural practice. That is a big issue all over the country.
that's a great point. Thank you. Um, any other closing remarks from our from folks? If not, then we're going to finish on time. That's kind of remarkable. I would like to point out that I just want to thank you for joining us today. And our next MLC webinar will be in January on the early intervention for evidence-based pathways for youth and mental health suicide prevention. That's in January. And I just want to thank you, Robert, and for joining us and making time for your presentation today. I also want to thank our chairs for being on here and helping us out. Um, everyone, we're just seeing some Merry Christmas and Happy Holiday wishes. So thank you once again. And with that, I will close out the webinar. Thank you so much.